Have you ever really stopped to think about what's in your trash? I mean, seriously. Old letters, prescription bottles, bank statements, maybe even a DNA sample on a used tissue. It paints a surprisingly detailed picture of your life, right? So here's the question. Do you have a right to privacy over the things you throw away? Well, that exact question went all the way to the Supreme Court of Canada.
So today we're going to break down the fascinating case of R.V. Patrick. We'll start with a simple tip-off in Calgary, follow the police as they search through the trash, and see how that puts our fundamental right to privacy on trial. Then we'll unpack the court's surprising logic, a really important disagreement among the judges, and finally, what this whole thing means for you.
All right, so our story kicks off in a regular suburban neighborhood in Calgary. The police had a pretty strong hunch that a man named Russell Patrick was running an ecstasy lab out of his house. But a hunch, no matter how strong it is, isn't enough to just barge in. To get inside that house legally, the police had to convince a judge to give them a search warrant. And to do that, they needed some kind of hard evidence that a crime was actually happening. So their investigation turned to something we all produce every single day: garbage. Okay, this is where the case gets really interesting. Since they couldn't just walk into the house, the police decided to see what secrets Patrick might be throwing out with his trash. And that decision is what set the stage for a major legal battle. And here's the crucial part. When the police went for his garbage, they didn't have a warrant. Not for the house, not for the trash, for nothing. They were just acting on their suspicion, hoping to find the evidence they needed. Which, of course, raises a huge question. If the garbage is on his property, how could the police possibly search it without a warrant? Well, the answer is all in the little details of how they did it. Okay, so check this out. Mr. Patrick put his garbage bags at the back of his property, right up against a public alley. Now, the bags were technically still on his side of the property line, so the police officers didn't actually step onto his land. Instead, they just reached over the invisible property line, through the airspace, and grabbed the bags. A tiny physical act, but one with huge legal consequences. And boom! What they found was an absolute goldmine for their investigation. Inside those bags were chemical recipes, packaging for a digital scale, and get this, other items that were literally contaminated with ecstasy. This was the smoking gun they needed to get their search warrant. So, with this evidence, Patrick was convicted. But he appealed, arguing that that whole garbage search in the first place was totally illegal. And suddenly, the entire case came down to one of the most important rights we have in Canada, the right to privacy.
We're talking about Section 8 of the Canadian Charter of Rights and Freedoms. This is the part of our Constitution that protects every single one of us from the government unreasonably poking around in our private lives. Patrick's argument was simple. Police snooping through his trash was a textbook unreasonable search. So how does a court decide if your privacy was actually violated? Well, they use this two-part test. First, the subjective part. Did you personally think what you were doing was private? But the second part is the real decider. Was that belief objectively reasonable? In other words, would a regular person agree with you? It's not just about what you think, it's about what society as a whole considers reasonable. Now, when this case finally landed in Canada's highest court, the entire decision came down to one powerful single idea: abandonment. So, what does abandonment mean in a legal sense? It's not about what you're thinking, it's about what you're doing. The court basically says that your actions can show that you've given up any reasonable expectation of privacy you might have had. And the court's reasoning is captured perfectly in this quote from the decision. They argued that by putting his trash out, Patrick made it available to, well, anyone. Street people, bottle pickers, nosy neighbors, and the police. He had essentially left his private information out in a public space. The court drew a really clear line in the sand here. If your garbage is still in your garage or on your porch, it's under your control, you've got a reasonable expectation of privacy. But the second you move it to your property line for collection, you signaled that you're done with it. You have, in the eyes of the law, abandoned it. So the final ruling was this. The Supreme Court said that because Mr. Patrick had abandoned his garbage, he also abandoned any reasonable expectation of privacy over it. And because of that, the police search, even without a warrant, was totally legal and didn't violate his charter rights. But hold on, the story isn't quite over. While most of the judges agreed on the outcome, one of them, Justice Abella, wrote her own separate opinion. She agreed Patrick's conviction should stand, but, and this is a really fascinating twist, she got to that conclusion using a completely different line of reasoning. Justice Abella's point was this: When we put our trash out, yeah, we're abandoning it, but we're doing it for one very specific purpose, for it to be picked up and taken away. We are not giving the government or anyone else a free pass to sift through our personal information.
And this slide really breaks down the disagreement. The majority said your privacy in curbside trash is completely abandoned. Gone. That means police don't need any suspicion at all to search it. But Justice Abella said our privacy interest is only diminished. It's weaker, but not gone completely. And because of that, she argued police should at least need a reasonable suspicion before they can start digging through it.
So after all that legal debate, what's the bottom line here? What does the law of the land actually say about your garbage and your privacy?
Let's just ask the question straight up. Once you put that trash bag at the end of your driveway, are its contents legally protected from a warrantless police search? Well, thanks to R.V. Patrick, the answer is pretty clear.
All right, let's recap the big takeaway. It all comes down to location, location, location. As long as your trash is in your garage or on your porch, it's private. The moment you put it at the curb for collection, the law says you have abandoned it. And that single act means you lose your constitutional protection against the police searching that trash without a warrant. It all boils down to that physical act of putting it out.
And that leaves us with a final, bigger question to think about. In the Patrick case, the court was talking about physical trash. But in our digital world, think about all the data trails we leave behind. Our search history, public social media posts, our location data. What parts of our digital lives are we abandoning every single day for anyone, including the government, to see? That's a question our courts are going to be wrestling with for years to come.